seminar. Today we have the pleasure to be joined by Professor Scott Hershovitz. Scott is a professor of law and a professor of philosophy at the University of Michigan. He directs Michigan's Learned Ethics program, and he's also an editor of the General Legal Theory. He writes about many topics in legal theory, including the nature of law, the rule of law, tort law, and many others. He has also a forthcoming book called Law is a Moral Practice, which will be published by the Harvard University Press this year. This evening, he will actually present a chapter from this book titled Stop in the Name of Law. Scott, thank you very much for accepting our invitation. In the name of the GDG, you have the floor.
Well, thank you very much. It feels really special to be back here, actually. I'm just going to reminisce for a moment because I was a participant in the Jurisprudence Discussion Group in the early days of its existence, from 1998 to 2001. It was a much smaller affair. We couldn't have even filled the table part of this room. Nick Barber was hosted at Brasenose, and we met in a small dining room there. We would go every week we would go for dinner at Pizza Express before the discussion group, and then back to Brasenose, and somebody would read a paper aloud. We didn't have guests, we didn't have a turn card. The thing that held it together actually was that John Gardner would come up from London, and people liked to hang out and listen to John, so that gave people a reason to show up every week, even when he wasn't presenting a paper. I also feel like it should be special to come back to Balliol. Balliol was my college, but I have never been in this room before, so this bit of it doesn't feel nostalgic at all. It's true that I have a book about jurisprudence in the works. It is probably also true that somewhere online I had listed it as forthcoming 2022. 2022 has arrived and it's definitely not forthcoming this year, but it will be published by Harvard University Press once I manage to finish it, and you can play a key part in that. I got distracted and have been working on another book which will be out this year, which is not at all about jurisprudence. And so it's been a while since I've worked on this, and I really appreciate the chance to come and talk to you about it, since it will give me a chance to get my head back in this book. And I thought I'd tell you a little bit about the book as a whole, and locate where the chapter that you read is in it, and then we can have a conversation really about any of it, about like the view in general, or the part of it that comes through in the chapter that you read. So the central idea of the book is captured in the title, which I think is not a great title, and I'd like to change it, but the title has this virtue. It states the thesis of the book, so anyone who wants to cite it has to articulate my thesis, which is that law is a moral practice. So what do I mean by that? Right? What I mean is that law is a practice that we participate in part because we want to create, extinguish, arrange, rearrange, or sometimes simply articulate our moral rights and responsibilities. That's not the only reason that we participate in legal practices. It may not even be the primary reason that we participate in many of our legal practices. We also very centrally want to change the way the world goes and change how people will act, and changing the law is often a way of changing people's behavior, right? But I think our legal practices have this aspect to them, that they're practices that we engage in the hopes of rearranging moral relationships. And that's actually a fairly widely shared view in jurisprudence. So in the first chapter of the book, where I introduce this idea that law is a moral practice and say what I mean by it, I then proceed to show how across the positivist and anti-positivist divide, lots of people articulate one or another version of these views. So Joseph Raz says that law claims authority, and he means by that law claims the power to obligate people to act in certain ways based on the orders that it's issued. Whether or not it has that power, it claims that power. Mark Greenberg once defended what he called the bindingness hypothesis, the hypothesis that that law is such that it's law. I'm trying to remember exactly how he put it. This will be a loose paraphrase. That it should be the case when legal practices are going well that for every legal obligation there's a moral obligation, right? And in regard that law is defective to the extent that's not true, right? So those are two people who are pretty polar views about the central question in jurisprudence, both articulating a version of the idea that these are practices that people engage in because they want to make a moral difference. And I take that as a kind of starting point for thinking about law. That claim comes with a corollary. That's the non-controversial claim. It comes with a corollary that is controversial. The corollary is that that legal claims are, well, actually, before I give you corollary and start on controversy, let me just say a little bit more about the idea that law is a moral practice. Right? So we have other moral practices, right? So think, for instance, about promising. It's something that you do, partly because you may want to change how you or others behave, but it's also something that you do to rearrange the moral bit of the world, to create moral rights and responsibilities where there were none before, right? Making requests can rearrange our moral relationships, making demands, making rules in various contexts, offering forgiveness affects moral relationships, swearing oaths affect moral relationships, right? And part of what I want to say in this book is law is continuous with these other moral practices. Indeed, in some ways, it may be built up out of simpler versions of moral practices. So there's a corollary, right, to the claim that law is one of these sorts of practices that aims to adjust our moral relationships. Legal claims, I suggest, in the first chapter of the book, are moral claims in a rather straightforward sense. They're claims about what we owe each other. And I think of as the book as a whole as a kind of invitation to try out that way of thinking about what somebody's doing when they make a legal claim. So the first chapter offers an extended illustration. It imagines that somebody is going to court in a tort suit. Tort law is what I know best. And saying, for instance, say they've been in a car accident, they've sued the person they believe to be responsible, and as I understand what they're doing, they're showing up to court and they're asserting a complicated right, a compound right. They're asserting a right to have a court enforce a right to compensation against the defendant. Right? And this claim could fail in a variety of ways. It could fail because there is no underlying right to compensation from the defendant. Maybe the defendant didn't do what they're accused of, right? Or maybe the defendant did what they were accused of, but it wasn't wrong that they did what they're accused of. So you could fail because you've got no underlying right to compensation. You could also fail for a different sort of reason. You could fail because you don't have a right to have the court enforce that right to compensation. Straightforward ways in which that might be true is though there may have been a moral wrong, there was no cause of action that corresponds to that moral wrong. Right? Or another, maybe even more clear way in which you could fail to have a right to have a court enforce a right to compensation is you may have waited too long to file your claim. Right? So we may think that as a matter of morality, this person really ought to pay for your injuries, but you showed up at court, passed the statutorily specified statute of limitations, you now lack a right to have a court order this person to compensate you for your claims. So the book, as I say, is an extended argument, or really I think of it less as an argument than an invitation to try out this view that legal rights are just rights of the ordinary moral sort, that legal obligations are just obligations of the ordinary moral sort. This view is probably not unfamiliar to you. I think of it as the view that Ronald Dworkin, he endorsed it very clearly at the very end of his career in Justice for Hedgehogs, but I think it has much deeper roots in his work. I think it's the view that he was trying to articulate and defend in Model of Rules 2 and Hard Cases. Those are, I think, his best and most widely misunderstood work. And unfortunately for him, it was sandwiched between Model of Rules 1 and Rawls' Empire, which are his most widely read works, and I think are actually, in ways that he didn't come to appreciate until later in his career, articulating a different kind of view of jurisprudence, and that's the one that's attracted all the attention. All right, so that's the project as a whole. I'm happy to talk more about what's in the book, but the general structure is take up this perspective with me, see law as a moral practice, see legal claims as moral claims, and then let's think first about whether this view is workable. So there's chapters about immoral laws and immoral legal practices, the sorts of things that drive people towards positivist pictures. So those chapters work through how they might be accommodated on this sort of way of thinking about law. Right? But another question is, what are the implications for the traditional debate about whether we're obligated to obey the law? And one thing I observed at the outset of this chapter is that the standard framing of this question, which goes back at least to Plato, presupposes that law and morality are separate normative systems, right? So that the question is, like, once we've identified the content of the law and we see that it assigns people certain rights and obligations, we ask, is there a moral obligation to, say, conform to your legal obligations? And I'm interested in how this debate looks if you reject that picture, if you think law and morality aren't two separate normative systems, that legal claims are moral claims, and as you see in the early bit of the chapter, that's what I'm working through. So I take M.B. Smith's classic article, Is There a Prima Facie Obligation to Obey the Law, as my foil. Smith says his question amounts to this: is there any legal system such that illegality is a prima facie reason to regard an act as wrong? Right? So just think, like, so he says lots of times violations of the law will be wrong. Like, that's not what he's after, right? He's just interested in the question, right? Is there any legal system? So imagine a legal system that's as good as working order as you possibly can, right? Does the mere fact that that legal system designates a particular act as illegal entail that it's wrong? And he says no. And for reasons I explain in the paper, I think he's right about that. Right? But the paper aims to suggest that there's a different way of construing the question. Right? When we think about whether we're obligated to obey the law, the alternative I suggest is we might wonder, do our legal practices ever succeed in rearranging our moral relationships such that we owe it to others to act as the law directs? And I think that the answer to that question, right, does the law succeed in rearranging our moral relationships so that we have obligations to others to act as it directs? I think the answer to that question is sometimes clearly yes. And I make my case with a case. So there's in the middle of the paper, there's our extended conversation about the RMZ case. This is the case where a 16-year-old boy sexually assaults a 16-year-old girl, and I think colloquially we'd probably just describe what he's accused of as rape, but the statutes in Oklahoma don't define it as rape because rape requires, if I'm recalling the details correctly, rape there requires vaginal penetration. He was alleged to have engaged in oral penetration, and but there was another statute that might have applied to the case. It prohibited forcible sodomy, and so that's what he's charged under. And as I described in the paper, he moves to dismiss the charge, and the motion is granted, and it's affirmed without a written opinion by the Oklahoma Court of Criminal Appeals, and this attracts widespread revulsion, and rightly so, but none of the commentators who were revulsed by the outcome of the case say that it was wrongly decided. Right? So why is the case rightly decided? Well, it's not just charged with sodomy, which would have covered any oral penetration. Is charged with forcible sodomy, and the statute contains this definition of what counts as forcible. And there was one bit of it that you thought, like, read out of context, might have applied to what he did. It said sodomy will count as forcible if it's perpetrated on someone who is unsound of mind or lacks the mental capacity to consent. And you might think, well, that applies to the victim's intoxication in this case, but the rape statute had a parallel set of provisions which contained that language and also contained two further provisions that referred explicitly to intoxication and explicitly to a lack of consciousness. And the courts, every court that looked at this case, considering those statutes as a whole, said, well, hey, look, in this parallel provision, just a little bit down in the Oklahoma Code, they called out these two things specifically. It must be that unsoundness of mind is referring merely to mental illness and not to intoxication or lack of consciousness. And so in the aftermath of this lawsuit, the Oklahoma legislature immediately springs into action. Like, it takes a matter of days from the decision to move a bill through the state legislature, adding these two provisions to the forcible sodomy section of the statute, and it seems quite likely, I should say, like this is increasingly common, at least, and maybe you guys have things working better here, it seems increasingly common in the states that we're ending up with statutes that are poorly written because of copy-paste errors, or like failure to integrate like two different versions of a Word document, that like failure to integrate two different versions of a Word document, like almost wholly vitiated what we call Obamacare, the kind of like dramatic expansion of healthcare that health insurance that President Obama shepherded through. And this seems to have been somebody cut and paste and grabbed 4 of the provisions rather than all 6 of the provisions. And with the result that the case against this boy was dismissed. And so the question I ask in the middle of the chapter that you read is, did that statute make a moral difference? And I want to say with Smith that if it made a moral difference, it wasn't this. It didn't make what the boy did wrongful, right? What the boy did was already wrongful, quite apart from what the Oklahoma statutes had to say about it. Indeed, one of the reasons that the legal situation in Oklahoma was so dreadfully awful was that it didn't manage to make criminal what was so morally abhorrent, and merely closing this gap in the law doesn't seem to affect my moral evaluation at all of what the boy did. But I don't think that means that the statute didn't make a moral difference. I think you just have to look elsewhere for the moral difference that it made. And the suggestion I make is that it rearranged the moral relationship between the boy and the state, which is to say, when he was charged, he came to court and he said, I have a right to have these charges dismissed because the state has not done the things it needs to do in order to hold me responsible for this conduct. In particular, it hasn't satisfied the conditions of the principle of legality. It hasn't announced in advance that this sort of conduct will count as a punishable offense. And I think that he had that moral right, not just a legal right. I actually think, for reasons I explain in the paper, and I think this is the reason that even very prominent commentators about the law of rape regarded this statute as wrongly decided, is because there's been a very serious moral issue at stake with the principle of legality. It's like the danger of actually, so like, as you see in the paper, like one of the things going on the side, but maybe also somewhat important, is I don't think that that the principle of legality, like the defense of it that's often articulated, is a defense that makes sense. Right? So we're often told that this is about notice, that people need to be told in advance what they might be held responsible for so they can adjust their behavior and avoid undesirable consequences. I think that when we're dealing with mala prohibita, something like that is probably true. You should be told that parking here rather than there might lead to a fine, because absent being told that, you might have no reason to suspect that there's anything wrong with parking here rather than there. But this crime is certainly not that, right? I don't think this boy, even at 16 years old, needed to be told that what he was doing was wrong. I suspect he already knew that what he was doing was wrong. And if he needed to be told, as I say in the paper, I don't think publishing it in Title 21 of the annotated statutes of Oklahoma was actually going to be a way of informing him. He was never going to, well, maybe not never, but he was not at 16 years old going to encounter them. So you ask, like, what else is going on, right? And the suggestion I make in the paper is that I think this is about constraining the power of the state, that it's there's something extraordinarily dangerous about a state that could define after the fact criminal offenses and deprive people of their liberty for committing them, because nothing would be easier than finding disfavored people, identifying something they've done, calling that a crime, and putting them in prison. So I think this is a commitment device, right? The state has got to tell us in advance how it intends to use this awesome power, which it has, and maybe in democratic political systems, this also warranted as a kind of aid to democratic control, right? That if you're not aware of how power is going to be used, you can't police its use. So I say actually the statute, right, didn't have the moral difference that Smith and many other people in these debates were looking for. It didn't create an obligation to obey the law, right, in the sense that, right, it turned something that wasn't wrongful, and it didn't, Smith says, even if an obligation to obey the law existed, in his view, it wouldn't be very important, because if something was already very wrongful, it wouldn't be all that much more wrongful. And I agree with that too. I don't think that somebody who violated this statute a week after it was, violated the revised statute a week after it was enacted was doing anything worse than the boy did for the fact that it had been made unlawful. I think like what had changed between the boy's case and whoever's case comes next is that that person won't be able to assert the right that the boy did. They won't be able to say, hey, state, you don't have the standing to punish me because you haven't jumped through the hoops that are necessary to extinguish my moral right to be free from punishment. And then there's the small suggestion that this may not be, well, actually I'll just say this is not the purpose of criminal law, right, is to make these sorts of changes, but I actually think it's like among the central purposes of criminal law is to make these sorts of changes in our moral relationship. Criminal law, like the rest of law, like I said up front, certainly aims to adjust the way that people behave by issuing threats, providing incentives, but ask why we want to live in a world where we don't just have a state that punishes people who've done bad things without any announcement in advance of what the crimes will be or with any process associated along with it. And I think the answer will be, right, that, the story I just spelled out for you and the purpose of having, right, the criminal code written and published and then implemented through procedures that have what in America we think of as satisfy the requirements of due process is, I think, to provide the state the standing it needs in order to punish people. So that's meant to be a kind of, so to think about the arc of the chapter for a moment, wants to concede to Smith that if what you're looking for is a reason to think that mere illegality makes conduct wrongful, you won't find it, but there's this really other interesting moral consequence of our legal practices that people do often end up with this obligation in a different sense, right, where they now, as I say, of the boy, I think he did, like at the outset, he owed it to the girl not to do what he did, right, but I think that future potential defendants in the state of Oklahoma also owe it not just to their victims, but to the state not to act in these ways. And I say I think that's part of what we mark when we use language like it is an offense against the state to do X or Y or Z. In the paper I suggest you have to be careful about using that kind of language. To say that it's an offense against the state is not to say that the state is the victim. It's not to say that it's the state's interests that are being vindicated. I suggest that the state holds this right because it's holding this right allows it to play a role for the victim, to play a role for other potential victims. I think of it as a kind of right that it holds in trust of the people who will be affected by the conduct. The last phase of the paper says, well, wait a minute, I just told you a story that's really, I think, simple and easy on my view, a story where we might become obligated to the state not to do things that's anyways wrong to do. And then the last phase of the paper asks, well, wait a minute, could we be obligated to the state to not to do things that would not be wrong to do? Those are the sorts of cases that have caused people worry about whether there's an obligation to obey the law. So we've got like the kind of classic case of you pull up at the stop sign in the middle of nowhere. And Roz once told us that if you stop, you'll amuse the gods. And we have to suppose, right, that, it's a clear day and you've got good vision and fill in the details so that we know nothing is at stake really for anyone as to whether or not you stop. And I say towards the end of the paper that again, like thinking about obligation differently than Smith does and differently than it's often thought of in these debates, not as the question whether the state's having put up the stop sign makes it wrong of you not to stop. I agree that in the right circumstances, you would do nothing wrong if you rolled through, right? But I nevertheless think it may be the case that the putting up of the stop sign affects the moral situation in just the same way that passage of the statute did in RMZ, that it gives the state the standing to punish you for this thing which may not be wrongful. And here I actually realized something new about this as I was rereading the chapter today. One of the things that Roz always wanted to say about examples like this after making you'll amuse the gods observation, he explained why it might be sensible to stop in this situation. He says, like, look, we as outsiders who created the hypothetical, we know, right, that there's absolutely no reason to stop, but it's actually somewhat costly to be gathering that information when you're driving. It's not unreasonable to be a mindless stopper at stop signs, right, because you avoid the cost of forming a judgment on any particular case about whether there's reasons to stop. So that's maybe a reason for the gods not to laugh. I realized today as I was reading the paper that my argument here is exploiting the same kind of epistemic concern that Joseph was, but from a different direction, which is to say that it may be apparent to you when you're there and you've invested these costs that there's no reason not to stop, right? But it may not be apparent to the state that plans to punish you that there were no reasons not to stop on that occasion. Now, most of the time this might just go unobserved, and there's no question that you won't be punished for it. But in the age of sensors and cameras, right? Maybe it will be observed, right? Maybe it's not unreasonable for the state to put sensors and cameras in places where there won't be police officers to observe traffic offenses, right? But those sensors and cameras aren't going to observe all aspects of the situation. They'll observe that you didn't stop, perhaps, right? But they're not going to have the 360 view in clear conditions that are necessary to know whether you properly judged the circumstances to be such that there was no danger to anybody. And I think that it matters the way these institutions work. They might, justifiably be unwilling to entertain your plea that there were no reasons not to do this on this occasion. And so this strikes me as the kind of case where you might think that the stop sign makes it the case that the state has standing to punish you, notwithstanding the fact that you've done nothing wrong. So all this ends up, and I realize I probably talked for much longer than I tried to talk.
Just on time.
Just on time. Yeah. Well, so the paper ends with a plea to pay attention to all the ways in which, or more ways in which, law is morally significant. So I find something super frustrating in conversations about this, that the traditional debate about whether there's an obligation to obey the law treats it like a general question. We're going to find an on-off switch, and then people propose, this is the first part of the paper, people propose all sorts of answers. We have a duty of fair play. We've consented tacitly, right? We have duties that flow from gratitude. We have duties to support just institutions. We have associative obligations. The problem is all those arguments are bad, right? And they're all known to be bad, except by the handful of people, none of whom are in this room, who want to defend one or another of them. And maybe that's a sign, I think, that this wasn't a great question to have asked in the first place. But if you ask, what are the moral consequences of our legal practices, I think you actually find really rich and unmined philosophical terrain. So I've tried to highlight one here, but there's lots of other questions you can ask. You can ask, well, what if the practices are bad? Should I resist them? Am I obligated to resist them? Right? Those are important kinds of moral questions, and the last section of the paper articulates, the last paragraph in the paper articulates others, but I will stop there and take your questions.
Thank you very much.